The debate over the judicial reform in Jamaica is heating up. The Judicial Committee of the Privy Council has withdrawn its controversial Rule 23 proposal, a move welcomed by legal experts who raised concerns. The rule would restrict certain constitutional rights, with the nation considering significant changes to its highest court of appeal. Our reporter Ramon Gordon spoke with an attorney with first-hand experience on the matter for this update.
As debate over judicial reform rages locally, legal experts are welcoming the latest decision by the Judicial Committee of the Privy Council, JCPC, to withdraw its controversial Rule 23 proposal. This rule had sparked fears it would limit the legal rights of all Jamaicans to appeal convictions. Rule 23 would have allowed petitions to the Privy Council to be reviewed by a lone judge or a panel of 3 to determine if an appeal was void of merit. If deemed so, appellants would have just 21 days to argue why their appeal should be heard. The Jamaican Bar Association JAMBAR strongly condemned the proposal in a letter dated May 14, outlining significant constitutional concerns. Attorney Bert Samuels, a vocal critic of the UK-based appeals court, had also expressed concern over the proposal.
There was consultation, they listened, and it has been withdrawn. I welcome the fact that the Privy Council listened to the voices of the attorneys.
This latest development comes amid intense local discussions on whether Jamaica should completely sever ties with the Foreign Appeals Court and embrace a domestic option. Critics argue that the Privy Council is not only costly, but also inaccessible for many Jamaicans.
You have to get a visa, the attorneys have to get a visa. They have been saying they can have virtual hearings, but what is being hidden from the public is that you have to appoint an agent who are solicitors in England who we have to pay, and their fees are as high as the barristers who argue. We have a weak currency, you have to pay in pounds, and many persons who would have been able to go to that court and possibly win their cases, because of the cost of going there, justice has not been realized.
The Constitutional Reform Committee, CRC, recently submitted its 100-page report from its first phase of consultations. However, 3 opposition CRC members withheld their assent as the team failed to reach a consensus on the nation's final appellate court. The committee has suggested a possible referendum on the matter.
So it is my view that we should move across the 3 layers of government: judiciary, Privy Council, the Parliament, and the executive. We should move them at one time. That's a huge move, and I think the people should have a say in that move.
The committee intends to address the issue of the Apex Court in the second phase of its consultations.
The entire monarchical system should have gone from our independence. We were fools to think that we were independent. Moving forward, we think that the Caribbean Court of Justice is well placed in our future.
Ramon Gordon for CVM News.